I'm John Ellis, an associate attorney at Kendall's law office. One of the most important benefits for veterans is called TDIU, which stands for Total Disability Individual Unemployability. If you are applying for individual unemployability, it's important to separate out the myths from the facts. One common myth is that you need to meet particular schedular percentage criteria to qualify for individual unemployability. It's true, most veterans receiving unemployability have one disability rated 60% or higher, or a combined rating of 70% or higher, with one disability rated at least 40%. However, it's also true veterans can qualify for extra schedular unemployability when they have evidence their disabilities prevent them from working, even though they don't meet the rating percentage requirements. Most often, this comes up with veterans that have back pain or other issues that prevent physically demanding work, and they don't have the education or training for desk work, but it can come up in other situations too. The second myth is you cannot receive unemployability if you've already retired. That's not true. VA cannot consider your age when deciding whether to grant unemployability. So, if your disabilities make you unable to work, it should not matter if you already retired from your job. VA cannot say they are denying unemployability because you are just too old to work. What matters is whether your service-connected disabilities now make you unable to work. Another common myth is you can't work at all while receiving unemployability. That makes sense since unemployable is part of the name. However, veterans receiving unemployability can still do some work so long as it isn't considered substantially gainful, such as part-time work, temporary jobs, or seasonal work. But the income earned cannot go over the poverty line. There's a limited exception where veterans receiving unemployability can even make wages above the poverty line if their job qualifies as a protected work environment. But be careful, that determination is made on a case-by-case basis. Generally, it means the employer is making accommodations beyond what's legally required, like extra breaks, a flexible schedule, or a reduced workload. Often, the employer is a family member or friend who employs the veteran to be supportive. Another myth is you'll qualify for TDIU just because you receive Social Security Disability Insurance, SSDI. Although SSDI has things in common with TDIU, each program has different rules and requirements. The biggest difference is SSDI considers all your disabilities, while TDIU only considers your service-connected disabilities. The final myth is that TDIU is permanent. That isn't true. If things change and you become able to do substantially gainful employment, you won't qualify anymore for unemployability. This could happen, for example, if you didn't have the background for a desk job, but then you used your GI Bill benefits to get education that made you qualified for desk work. You would then go back to receiving your VA benefits based on the percentage ratings for your conditions. Navigating VA benefits like TDIU can be complicated, so reach out to our office for assistance with your claims.